Google is pushing back strongly against a Justice Department proposal that aims to prevent it from bundling its popular apps like YouTube and Google Maps together with its new Gemini artificial intelligence AI service. This challenge was presented during a court session on Wednesday, October 8th, where Google emphasized that neither its video streaming and mapping apps nor its AI service have been legally determined to hold monopoly status. But here's where it gets controversial. Could bundling AI with its apps actually stifle competition in ways the court hasn't yet fully explored? The backdrop to this legal dispute is a broader antitrust case where the judge found Google to hold a monopoly in search and search advertising markets. Currently, the court is deciding the specific remedies to address this monopoly. As reported by Bloomberg, Google lawyer John Schmidtlein argued in court that the AI market itself hasn't been proven to be monopolized by Google, nor are YouTube or Google Maps considered monopoly products, a critical distinction that could impact the restrictions imposed on the company. Judge Amit Mehta, who is overseeing the case, previously ruled in September that Google could no longer require companies to exclusively use its search engine Chrome browser or Google Play Store as a condition of business deals. Now, the heated debate is about whether similar restrictions should be applied to Google's Gemini AI, particularly concerning its bundling with YouTube and Maps. The Justice Department insists that the same logic used to limit Google's dominance in Search, Chrome, and Play Store should extend to Gemini. Conversely, Judge Mehta expressed uncertainty about whether it should be permissible for Google to force device manufacturers to include Gemini if they want access to YouTube or Google Maps. This ongoing tug-of-war highlights the complexity of regulating emerging AI technologies amidst established digital ecosystems. This legal battle has been years in the making. In August 2024, Judge Mehta determined that Google's practices violated antitrust laws by abusing its monopoly power in search and advertising. The case revealed how Google's business strategies created significant barriers for competitors and hindered innovation, reinforcing its monopolistic control over the market. The Department of Justice's lawsuit, originally filed in October 2020 alongside 11 states, accused Google of anti-competitive tactics designed to preserve an unfair hold on search and advertising dominance. This has sparked wide debate about the balance between innovation and competition in the tech industry. Interestingly, during closing arguments on potential remedies earlier this year, the government spotlighted the role of AI, specifically insisting that any antitrust remedies must consider Google's Gemini AI service. Justice Department lawyer David Dahlquist noted, "The reason we are so focused on generative AI is that it represents the new gateway to search access points, signaling that AI isn't just a tool but could reshape entire markets and possibly entrench monopolies. And this is the part most people miss. While AI is heralded as the future, it also raises serious questions about how dominant companies might leverage this technology to cement their power further. Should regulatory efforts be more aggressive in controlling AI bundling, or could such restrictions hinder innovation? What do you think? Is Google right to say Gemini isn't a monopoly, or is this a slippery slope that needs a firmer legal hand? Your thoughts on this complex intersection between AI innovation and antitrust enforcement could spark a vital conversation.